Good afternoon, everyone. Thank you for joining. Thank you for joining us for the launch and panel discussion on the report titled Regulating Data in India and Indonesia. This hybrid event is jointly organized by the Konrad-Adenauer-Stiftung Rule of Law Program Asia Singapore, the Institute of South Asian Studies, National University of Singapore, and the University of Gadjah, Mada, Indonesia. This report was prepared as a collaboration between the three organizations. Today's event launches a new report that covers how India and Indonesia have sought to regulate data or create rules that govern how data is collected, processed, stored, and shared. Before we proceed with the event, may I request all the participants and guests to keep their mobile phones on silent mode. Today, we are delighted to welcome the following panelists who are on stage. Dr. Karthik Nachiappan, Research Fellow, Institute of South Asian Studies, National University of Singapore. Dr. Natalie Pang, Senior Lecturer, Department of Communications and New Media, National University of Singapore. And joining us via Zoom will be Dr. Mulya Amri, Adjunct Researcher, Center for Digital Society, University of Gadjah Mada, Indonesia. The event will first begin with a presentation by the authors of the report, Dr. Karthik Nachiappan and Dr. Mulya Amri. Following this, we will host the panel discussion where Dr. Natalie Pang will join them as a panelist. Associate Professor Warren Chik, Associate Professor of Law and Deputy Director, Center for AI and Data Governance, Singapore Management University, will moderate the discussion via Zoom. I now invite Mr. Stefan Samse, Director, KAS Rule of Law Program Asia Singapore, to deliver the welcome remarks.
Good afternoon and warm welcome in and from Singapore. Welcome on behalf of the Konrad-Adenauer Foundation, KAS, and also very much so on behalf of the Institute of South Asian Studies, ISAS, at Singapore's NUS, and likewise on behalf of the Center for Digital Society, CfDS, at University of Gadjah Mada, Indonesia. It feels good, very good to see you all today. Here in Singapore, in Indonesia, and also following us via live stream. In pre-pandemic times, I would have asked you at this point, at the beginning of a LAN conference, if you had a pleasant journey and a comfortable flight. Well, I guess we are not at that point yet, obviously. All the more, we are pleased that you have taken the time to join us this afternoon for the launch of the joint comparative study on regulating data in India and Indonesia. KAS Rule of Law Program Asia is dedicated to working with Asian partners towards the development of rule of law. We have initiated our digitalization program to take stock of the regional development regarding the emergence of new media and advanced technologies. One of the particular areas of focus is to explore the interplay between technology, society, and law. Well, technology, society, and law. You know, when I'm talking to my 18-year-old son, for example, I sometimes get the impression that at least from the younger generation's point of view, those three pillars are not really balanced anymore. I mean, there's no way to get him into law. It's rather IT, tech, and for example, games designing that is the future, according to what he tells me. Well, he did not say law is old school, but that was the bottom line, at least sometimes in the conversations we have. But I'm still convinced that legal policy and lawmaking will, at the end of the day, keep up with developments on the tech side. The European Union's General Data Protection Regulation, GDPR, for example, has influenced legal policy in India and Indonesia. I remember that after the GDPR had been introduced, fierce debates took place in India, for instance, regarding the consequences for Indian companies. Well, some in Europe regard the GDPR as a milestone. Others are quite critical and argue that, that the GDPR is one of the very reasons why the digital side of the fight of the pandemic is not working the way it could work, for example, when it comes to tracing the clusters. Well, the approach regarding data protection is to some extent different in Asia and Europe, obviously. In Europe, still very often the approach is to avoid data and the collection of data. And why is it so? Well, various reasons in Europe. One of many reasons, but a reason not to be neglected is one can see when one looks into history. Germany, for example, had 2 dictatorships in the 20th century, and the last one ending only 30 years ago in 1989, 1990. And the East German government at the time was very much obsessed with collection of data, with surveillance and so forth. That is one of the reasons why citizens in Germany, for example, are still very much alert when it comes to the gathering, the agglomeration of data in any way, in any sense. India and Indonesia are both booming digital economies. The legislative framework to regulate data and the way data is collected, stored, and shared will be discussed today. The findings and experiences are of great interest, of course, here in this region, but also very much in Europe. Asia and Europe have long mutually benefited from each other in any case, and in this case regarding these issues and topics, very much so too. The key findings and the results of this policy report and the workshop today, we will transfer to the European and German debate through our political channels and networks. Well, let me thank you once again for the commitment on ISAS side and on CfDS side, and for putting so much time and energy into conducting this study. On ISAS side, there were Dr. Karthik, Nachiappan, and also today with us, Dr. Ronojoy Sen, and of course, Konrad-Adenauer-Stiftung Singh. Thank you very much. At CfDS side, it is Dr. Mulya Amri and his whole team. Our authors will be joined by Dr. Natalie Pang on the panel. Natalie Pang's work focuses inter alia on the intersection of technology and society. We will add another component today, law and regulation. I'm thankful that Warren Chik will moderate today, law professor at Singapore Management University and expert in data and data protection issues. Looking at today's hybrid conference and the enormous challenges of preparing it under the circumstances we still have, we do owe very special thanks to Jordan Enck and his team at ISAS here in Singapore, as well as to my dear colleague Aishwarya Natarajan in Jakarta for setting all this up. Aishwarya is in our team at the Rule of Law program, Asia, at the Konrad-Adenauer Foundation, in charge of our legal tech policy department. Let me now hand over to Karthik and Mulya for their presentation of the findings of the report on regulating data in India and Indonesia. Looking very much forward to your presentation and of course to the panel discussion afterwards. Please, the floor is yours. Thank you very much.
Great, thank you, Stefan. Before I start, I just want to thank the KAS Rule of Law program again, and the ISAS team for organizing this event. You know, it's hard enough to organize this during normal times, but even more so during challenging times, especially in a hybrid manner. So thank you once again. And also I want to just recognize and thank the CfDS team who we've been working with for the past year. Online. We've been having countless Zoom calls and conversations with folks in Jakarta and at CfDS, so Mulya, Dia, Janitra, Thank you so much. It was great to work with you and get a better sense of what's happening in Indonesia. So what I'm going to do in the next 10 minutes or so is introduce the report, talk about its genesis and why we spent so much time on it. Second, I'll cover some of the pressures driving the regulation of data in India. And finally, talk very briefly about the comparison, India and Indonesia, before giving it to Mulya, who will cover the Indonesian part of the report. So first, before I get into the specifics of what's happening in India on the data front, I think it's important to recognize that the Asia Pacific is home to some of the largest and rapidly growing digital economies in the world, which has emerged as increasing numbers of people are getting online. So internet penetration and use across Asia has exponentially grown. And the signs of the region's digital transformation are actually quite obvious from these trends. So you see impressive tech unicorns in most countries, especially India and Indonesia. You see entrepreneurs in smaller firms in both countries developing digital applications and services. And you have the big tech firms, but also big industrial firms who are getting into the digital space and are using technology as a major part of their operations. So, and all of this is driving a high level of interest from the region's governments to foster a more inclusive digitalization, one that emphasizes privacy, one that emphasizes consent, and one where the interests of citizens and users, digital users, are not lost relative to that of these bigger firms and governments. But this inclusive digitalization, and whether we even get that, and the growth of these digital economies across the region hinge and come down to one resource or factor, data, and how data is regulated and governed. So in other words, the domestic rules governing the collection, the processing, the storage, and sharing of data. So when it comes to data governance, we often see a few models, so namely the American approach, which rests on a light touch regulatory market-oriented framework that allows for free flow of data and data sharing. The Chinese approach, which rests on a strict localization with very limited data sharing. And then the European approach, the GDPR, which is a human-centered model that emphasizes privacy and the digital rights of users. But there are other approaches and ways in which data is and can be governed, approaches that don't get enough attention. Two countries that come to mind here are India and Indonesia, two Asian powers, large populous democracies that are also developing countries with booming digital economies, rising internet use, and vibrant civil societies who often hold their governments accountable on digital matters. Both are also countries that are and have been trying to legislate new rules to govern data. So the focus of this report is to highlight how these two Asian countries with dynamic digital economies are regulating data, or specifically legislations and rules, and what are the factors, conditions, and pressures driving the regulatory process in both countries. These issues are important because how India and Indonesia regulate data will signal their intentions and priorities to external partners, both countries like the United States and countries in the EU, but also big tech firms that are keen to invest in these two economies, but also domestic tech firms in both countries who require clarity when developing digital products and services for a global market. And we argue that India and Indonesia's digital future rests on the laws adopted to regulate digital economies and cross-border digital transactions, especially data. So the report describes and analyzes how India and Indonesia have attempted to regulate data, focusing on the political and institutional factors and actors. The first section unpacks India's efforts to regulate data, focusing on the 2018 and the 2019 Data Protection Bill. The second section focuses on Indonesia's efforts and likewise covers the range of regulations and rules that have led to discussions around Indonesia's data protection law. And the third section compares and contrasts both countries' experiences, drawing some broad takeaways vis-a-vis the regulation of data in both countries. And finally, the conclusion marks some of the challenges and opportunities that lie ahead for both countries along this pathway. So what I'm going to do next is talk about what's been happening in India. So India has been in the throes of finalizing a data protection law and framework that would govern data domestically. This impetus began in 2017 when the Justice Sri Krishna Committee was formed to draft a data protection legislation. The committee met, it had a very open and had a very open membership with members from different parts of Indian society. And the output was a very ambitious legislation that covered different aspects of data. So what is data? What are the different types of data? What's the role of citizens vis-a-vis data? The responsibilities of the state and other entities that collect data, and also finally, how to enforce these rules. So first, what are the pressures and factors that have shaped this new legislation in India? A key driver behind India's efforts to regulate data was digitalization, accelerated by India's mobile revolution, increased internet usage and digital penetration that led to increased data use, which then generated new concerns related to privacy. So some of these concerns were also raised by India's Aadhaar program, which collected and houses the digital identities of Indian citizens and has been fundamental towards several development efforts, including the effort to create a more inclusive financial system. So what became crucial here with respect to Aadhaar was the question of privacy, whether citizens, Indian citizens, had a right to privacy as they engaged and interacted with the digital economy and without risk. This question was answered by the Indian Supreme Court, which in a major judgment in 2017 declared that a fundamental right to privacy does exist under the under the Indian Constitution, and that the Indian government must work to ensure that new policies reflect this new right, except when absolutely necessary. So privacy concerns drove initial data discussions. So as we have seen in India's draft data protection law, there's a clear desire to identify the rights of users or data principals who provide their data over to data fiduciaries or the entities, whether that's private firms or the government or other organizations that collect data. So Indian citizens, regardless of their socioeconomic status or income level, certainly do care about their personal information and data, and they don't easily concede that the state or other entities own their data and personal information and can do as they see fit with that data. So that was one clear motivation and consideration, privacy and the rights of digital users. But that was not the sole consideration or motivation. As with any law or legislative endeavor, the interests of the public must be balanced or weighed against that of the government and other private interests. And so in India, two key interests or actors are crucial: the Indian state and capital. So Indian officials back then, and possibly even now, have a belief that data is a sovereign asset that should be publicly owned and protected and used for various public policy purposes. This motivation is clearly reflected in provisions that call certain forms of data to be localized or stored in India, either a complete localization or conditional localization, though this provision calling for localization has been softened in the latest version of the bill. The Indian state clearly believes that it has the right to access or procure personal data should the circumstance present itself for either economic purposes, security, or to provide various public goods like welfare and different entitlements. In other words, the state should have unhindered access to data when they require it. And the latest version of the bill, which was released in December 2019, goes even further. It does not have adequate or any meaningful constraints when it comes to the government's role vis-a-vis data. The government essentially exempts itself from the law, the draft law. So if you look at the state, and I'm using that conception quite broadly, there's a sentiment that data is a national asset and it should be publicly owned and leveraged for various public policy purposes. Moreover, it's somewhat clear to me that the government seeks political control of data to also transform the nature of the administrative state, to modernize it and make it more smoother and agile, to implement policy objectives in various development issues and areas like agriculture, like health, like education or transport. So that's the state. So the second actor is capital. And here, when you're looking at capital, when you're looking at the private sector, you need to differentiate between those that are big and small, and also those that are foreign and domestic. So if you look at small and medium-sized businesses in India, most are just awaking or to a policy context where they have to take data and data protection seriously. They have to have robust rules to manage customer data and have clear procedures internally that stipulate how they are going to first collect data, how they're going to store them and process them. So they have to have robust rules to not just manage that data, but also they have to have the capacity to comply with new legislations and rules around data. In that sense, their concerns to this bill are shaped by their ability to comply with the new law. So localization or not, they have to figure out a way to operate with these new data rules and a new data framework, regardless of how long that might take. For big businesses and some startups in the e-commerce sector and the digital economy, this is quite different. Given their scale of operations, they want control of data that they collect, which also affects the business models and services that they provide. And these interests color their views on how data should be regulated, emphasizing some form of localization. So you have certain conglomerates like Reliance, for example, who have been vocal proponents of data localization and have used colonial tropes to ensure that the Indian government does not hand data over to foreign tech companies or to subscribe to multilateral data rules which emphasize open data sharing. So these big tech firms rely on data to create new applications and services, but they're also hopeful of tying this data and the softwares with their physical counterparts, which is something that companies like Reliance are trying to do. So these are the two main actors, besides the citizens and the users in India, who have been shaping and influencing the data protection bill. So discussions on data in India oscillate between notions of control. Who should control and deploy data for economic purposes and innovation, and how democratic this process should be, and how do we protect the rights of citizens that are providing their data to tech firms, governments, and other entities. So this is, I think, the fundamental challenge and question when it comes to data governance. And getting this right, getting this balance right between control and privacy will also shape the new institutional architecture that is emerging in India to manage data, the Data Protection Authority, or the DPA, and how it eventually functions. So I want to just end by making a point, and this is a good segue to Mulya's comments on Indonesia, by making a point that this sort of balance between control and privacy is also something that ties India and Indonesia, and how they want to go about regulating data, and how they want to arrive at a law that balances these different concerns: privacy, security, innovation, and providing various digital public services to their citizens. So, thank you.
Dr. Mulya, you can now present the findings on Indonesia.
Okay, thank you very much. Good afternoon, everybody. It's a pleasure to join this amazing forum. We are joining from different parts of the world, but as Stefan says, our condition forces us to be in this situation, but we make the most of it, and hopefully we will still be able to work together and does not reduce our effort and our interest in this very important topic. So I will follow on from Karthik to share some of the findings of the report from the Indonesia side. I do have a little bit of PowerPoint presentation just to help me show some of the main ideas that were that we found in the report itself. So about the regulated data in Indonesia, I think Karthik has given a very good overview of the data in India, and Stefan has given an overview of the importance of this research in itself. But in Indonesia, the urgency of creating this data protection regulation is driven primarily by several points. The first one is that there is a low level of awareness on data privacy. So despite a high number of internet users and digital activities, I mean, we've seen reports saying that internet penetration in Indonesia is 64%, which is equivalent to 175 million people using the internet. 59% penetration of social media, equivalent to 160 million people. And of those using the internet, they spend time of 8 hours a day during using the internet. So it's a very important topic. And between 2015 and 2020, as the latest report from Google, Temasek, and Bain shows, that the value of Indonesia's digital economy grew from 8 billion to 40 billion US dollars. But we see that there's still low levels of awareness. Various surveys that has been conducted, including that we have conducted together with the Ministry of ICT, for example, found a low level of digital literacy. There is, in order for the digital economy to keep growing, there needs to be a stronger data protection regulation to enable more consistency and clarity on how the digital economy is going to be governed. We do have several cases of data breaches, which unfortunately shows the level of susceptibility of Indonesia's digital ecosystem to different kind of digital crimes. We've seen cases of the General Elections Commission. They experienced a data breach of 2.3 million voter information. And we have a couple of data breaches or threats of data breaches related to e-commerce platforms as well. So without appropriate regulation, a prosecution of these data breaches would be difficult. And of course, we are in the process of drafting the personal data protection law, but there is intense political pressures, not just from the different ministries, but different stakeholders as well. So there is this kind of urgency that specifies why a data protection regulation is direly needed in Indonesia. And we do have data protection regulations, but they are scattered in the different sectors. So it's a very siloed approach. So you can say that it's a fragmented, very sector-based approach to regulatory, to the regulation of data protection. So for example, the most complete form of data protection regulations is from the ICT sector. They focus on data confidentiality, and there have been some improvements and progresses. For example, information tapping is forbidden, but there are loopholes such as telcos can still do it based on service users' request. These regulations also adopt the principle of the right to be forgotten and requires electronic systems to erase irrelevant information. but then irrelevant, the term irrelevant is not yet defined. And moving personal data should require authorization, but to show that data is moved unlawfully, it requires a complicated legal process. So we are taking steps forward to improve the data protection regulations, but there are still loopholes. In terms of trade and commerce, for example, the data protection the emphasis is more on products and services rather than the customer's personal data, which is understandably because this is regulations that concern the trade and commerce sector, but it's just not yet complete because they are regulating aspects that are related to trade and commerce, but not so much on the personal data protection part. In terms of banking and financial services, there is a focus on customer data confidentiality. So banks are required to protect the confidentiality of all customer information, but these pertain largely to the customer's financial data and not so much on their personal data or their personal identity. In the health sector, the medical records are classified, but there is no sanction specified for breach of such medical records. And of course, the civil administration, India has shown that it can achieve much progress with the Aadhaar. Indonesia is still trying to follow behind. The regulations on data protection regarding civil administration is plenty, but there's still, of course, loopholes as well. There's different definitions of sensitive data, for example, which can create confusion in terms of people who are implementing this regulation in the civil administration. So there is progress, but there are still a lot of loopholes as well. So the personal data protection law, which is in draft form and under discussion with the House of Representatives, is something that we welcome. It is something that we think is overdue, but the formulation of this law encounters great challenges. So the draft has actually been initiated since 2010. So we're now already in the 11th year of this draft, and the latest draft is still under review by the House of Representatives. It takes a while, but it should be issued this year. The Ministry of Information and Communications, for example, admits that there are challenges, such as getting agreements among the different ministries and government bodies to harmonize these sectoral regulations that I mentioned earlier. So the key is actually to try to balance the personal data protection requirements with digital innovation as well. So some issues on the draft PDP law that we have identified, for example, we mentioned a balance between data protection, personal data protection, and digital innovation. So there are discussions on whether and to what extent the government should or can share Indonesians' public information with the private sector. So, of course, trying to balance innovation, economic growth, but also with personal data protection. There's also the issue of data sovereignty. This is also related to nationalistic sentiments about how can we ensure that Indonesia as a country, as a nation, is in charge of the data of Indonesians. So the location of data centers is also part of the issues being discussed in the draft PDP law for companies that manage data on Indonesians, for example. Where should the data center be located? Companies operating in Indonesia, even if they are global companies. So a discussion of whether a data center should be established in Indonesia, that's also part of the issues being discussed within the draft law. There's also internal concerns about the government's or the public sector's capacity to comply and on the public's compliance and the government's capacity to enforce such regulations. So, of course, the extent to which the law should regulate should also depend on the state's capacity to enforce it. So that's also part of the discussion. Again, internally within the government, there's a discussion on the formation of a data protection body. So this One of the references that is being used is, or being discussed, is the UK's Information Commissioner's Office, the ICO. But in Indonesia, there's already so many commissions and bodies. So one of the points being raised is that an additional body would be costly to the government. So another option that is being discussed is that, okay, if it's not going to be a new body, then it should be tucked under an existing ministry. That would reduce the cost of establishing this body. But then again, since personal data is a multi-sectoral issue, as I mentioned earlier, the different sectors working on data, there's a concern that if we tuck it in under one of the ministries, then how can it be effective in regulating other ministries, right? So these are some of the issues that are being discussed within the draft PDP law, which brings us to a little bit of a mapping of the actors related to data governance. So in terms of the data regulators, we identify the different ministries: the Ministry of Communications and Information, Ministry of Law and Human Rights, Ministry of Home Affairs. There's also the National Cyber and Cryptic Body, and of course, the House of Representatives, which is now discussing the draft. Electronic system managers are, of course, the range of different government and non-government institutions that manage user data. So this include e-commerce companies, social media, technology industries, telcos, but also government bodies such as ministries and national commissions, national and local governments that also manage these data from the citizens. And in terms of NGOs, we have different NGOs working on this topic: SafeNet, for example, ICT Watch, LSAM, TIFA Foundation as well. So we have a good range of people working on data governance. And the issue now is, of course, to make it happen, how to balance the regulation so that it's effective, it's protective of users' data, but also does not inhibit economic growth and digital innovation. So the foreseen implementation challenges is some of these is also, of course, low level of compliance among Indonesian citizens. A lot of these are due to the low level of digital literacy, so which is a main challenge. But that's, of course, hopefully the draft PDP law will also address that to improve and to enhance more efforts aimed at increasing digital literacy as well. But there's also other major events as all nations are experiencing now. The COVID-19 pandemic has shifted some of the interest and discussion and resources to discussing this topic. So these are some of the issues that are faced in Indonesia. Of course, I would be very happy to discuss this further with you all. Thank you very much.
Thank you, Dr. Nachiappan and Dr. Amri, for your insightful presentations. I would now like to invite Professor Chik to moderate the discussion. Professor Chik, please.
Thank you. Good afternoon, everyone. Thank you for joining us today. And we have on the panel with us Karthik and Mulya, who have already made their presentations, as well as Dr. Natalie Pang as well. So I'd like to start out with continuing the discussion on the challenges that these countries are facing, and in fact every country is facing, given the situation of the pandemic. And this picks up from what Mulya ended up with, which is, are there any impediments that are being caused by the pandemic to ramping up the data protection laws and the implementation for both Indonesia and India? And also the other issue of demographics as well, right? Are these rights sort of not within reach of certain segments of society, given that like you said, these kind of challenges relating to the fact that there are so many people in society, and there's such a wide gap between the rich and the poor as well. So maybe you can start out with, maybe Karthik can address this, because I know that from my experience with these laws, it has taken quite a number of years to even reach this stage. And now with the pandemic, I think that can be a sort of more of a problem for these laws to be prescribed.
Sorry, Warren, I was hoping we could get Dr. Pang to speak first and maybe place the Indian and Indonesian data experiences in a more broader regional context before we come back and talk about the specific issues related to the governance and the laws that are being debated in India and Indonesia. So I'm going to turn it over to Dr. Pang first.
Okay, sure. Thanks, Karthik, and thanks, Warren, for posing the question, which is a great question, and I promise to end on that note, right? So we can start that discussion. So, yeah, good afternoon, everyone in the room and people who are online. It's very nice to actually meet all of you. I'd like to thank ISAS and KAS and the Center for Digital Society for having me. I will, I guess, share some broad points based on a project I've been working on, which is a project to look into the area of data innovation and privacy and governance across 7 Asian cities of Singapore, Taiwan, India, South Korea, China, Hong Kong, and Japan. It's still ongoing. Some of the projects are still being, the reports are still being finalized, but I do have the key findings in already. So in that project, there are 3 sort of thematic areas I looked into. The first is about narratives about data. I think as we are talking about data protection and regulations, I think there is this inherent assumption that these regulations are able to protect data in some way. But my project looks into the narratives about data. How do people see its value, as well as how do different actors in each country sort of assess the ethical aspects of data protection and privacy. In the project, I also look into the laws and regulations that apply to data protection. But I think for me, what's also interesting is to look at the differences between countries, right? In terms of how regulations may also be explored to kind of foster innovations at the same time. Because sometimes I think we think of data protection and innovation as a trade-off, right? There is this overarching narrative that I do encounter in my fieldwork where I think especially private companies and tech platforms think of regulations as something that inhibits innovation. But for me, what's also interesting is to actually interrogate that tension, whether or not it's necessarily a tension. So yeah, and I think for me, what's interesting is also like encountering policymakers and regulators who don't necessarily think of regulations as inhibiting innovation, but think about regulations as trying to foster innovations at the same time. And the other theme that I look at is actually the wider ecosystem in every country, because yeah, for me, actually looking at the types of data being collected as well as the governance of data, we have to kind of understand the ecosystem that's actually producing it. So in China, for instance, there are the kinds of innovations that's there, right? The laws are actually developed aggressively for innovation. So the issue of data protection actually is only up and coming right now, right? So in thinking about the privacy and protection of data in certain parts of Asia, right, it's not necessarily very advanced. So some countries like China is just starting to think about it. And with their latest bill that looks into data protection, we'll have to see, further debates about that. For me, I think, one of the other broader observations I could draw, right, is also the role of the state, right, in terms of protecting data and how they drive innovations at the same time. So in the countries like Korea and Singapore, I would observe that I have observed that it's very top-down kind of state-driven process and approach. In countries like Taiwan, there's a stronger voice, right, and participation from civil society. So, so yeah, I mean, this leads me also to the question of the role of civil society and citizenry, and whether or not in the pursuit of data protection and also the wider infrastructure, looking into the governance and protection of data, can we also explore opportunities to design pathways for citizens, right, to participate? What is the role of the citizen, right? And how do we bring citizens into this policy making, and as well as making choices in terms of, their data and how it's going to be collected and used. I think the other thing that I would like to, I guess, talk about, right, is about choice. And this goes back to Warren's question, because I often think that choice is often thought of as an exercise in individual agency. But how can we also rethink the availability of choice for particular segments, demographic segments, for certain parts of, for certain parts of our society, people who don't have actually the necessary digital literacy, for instance, they experience choice in terms of data protection very differently, right? Whether or not they understand the implications of what they're doing with regards to privacy settings, when when tech platforms, for instance, leaves individuals to exercise their choices in terms of reading complicated, right, privacy updates and notifications. What does that mean for certain segments of our society that actually don't necessarily understand the implications of these choices? So, this also goes back to, I think, this interesting trade-off that I also saw between, actually consent and, understandings of public good. So I think it was Mulya who raised also the context of COVID-19 right now, in your project. So I think what's be interesting for me, right, doing sort of fieldwork other than the challenge of trying to do fieldwork during COVID-19. But for me in the project, actually what's been very fascinating for me to observe is also how different countries have been able to deal with COVID-19, specifically contact tracing, right? In countries like South Korea, where there are laws there to allow for non-consensual collection of data. Contact tracing has been sort of relatively effective compared to other countries, right, where they don't have laws to facilitate that kind of collection of data, right? Contact tracing is something that's more voluntary and relatively less muted in terms of its effectiveness. So this, I think there is this interesting trade-off as well between consent and our understanding of public good. So I think I have just given broad points, right, in terms of the broader regional context. If there are questions about specific countries, I'll be very interested to, I'll be happy to address them as well.
Yeah, there'll be some time for Q&A later on as well at 4:25. But thank you, Natalie. I think certainly that overview of what's happening in the region as a whole is very, very helpful to contextualize what is happening in India and in Indonesia as well. And certainly, you know, the issue of prioritization now, right? I mean, like you said, you know, so it's all well and good in the normal situation, you know, when the world is in a normal situation where you say, okay, we give you privacy rights and everything. But now with what's happening, you know, that those rights may not be as important to the individual, you know, even though of course this is a form of human rights in the current context than other needs like health needs. And when you talk about health needs, then there may be a requirement to, you know, to collect information and everything that's may not be generally consistent with the basic obligations like, you know, immediately seeking consent, especially in the emergency situation. But let's go to Karthik now, and maybe you can give a little bit more light on what's happening in India in relation to these challenges.
Well, so let me just maybe take a step back and talk about what's happening specifically with respect to the bill, and then maybe bring in the pandemic and how that's changed some of the discussions around data in India over the last year or so. So right now, the second iteration of the data protection bill is currently being discussed in Parliament. It's scrutinized by a joint parliamentary committee with representatives from both the upper and lower house who will come, who are assembling to discuss various provisions of the bill and in what form should they allow the bill to go to the main house for assent to be passed. So there's been a lot of controversy around this because the way the government has organized this committee, they've placed members who are from their own party and not the opposing parties, who might raise issues and considerations around some of the criticisms of the bill, namely what the specific role of the government should be relative to data collection, why is the government exempting and government agents are exempted from some of the key provisions of the bill, so on and so forth. So a lot of those discussions are ongoing, and we still don't have a final version of the bill. We don't know whether the second iteration of the bill, which was more controversial than the first one, because it softened some of the provisions around localization, you know, while exempting the government from the law itself would remain. But it looks to me like this version of the bill will go ahead as planned, because it allows the government to use data to create new digital infrastructures, whether that's in the health space, whether that's in other specific areas, whether that's providing different kinds of entitlements and subsidies to citizens. So data gives the government, the Indian government, a tool, a resource to create new infrastructures around which it can organize itself. It can entrench itself in the lives of Indian citizens more than it's ever been. And relative to what's happening with the pandemic, I mean, India had an app which is called Arogya Setu, and it made it mandatory for a certain time for its citizens to download it, so they can track if anybody has contracted, or if anybody they know has contracted COVID within their own neighborhoods. But the app is also, and the government hopes for the app to not just serve as this tracing and this contact tracing application, but also a broader kind of platform to provide different kinds of health information. Right? And so there are other agendas, there are other kind of ideas in place for expanding this contact tracing app to become a healthcare application. So for that, the government needs access to data, they need access to geographic data, they need access to different kinds of health records, and they need access whether or not, you know, I think citizens are willing to provide that information or not. And I think the pandemic has not just given the government more of a license, more of an opportunity to not just collect data, different kinds of data, but also use that data to create new policies, to create new digital infrastructures that they can use to create services, that they can use to also, manage different kinds of issues relating to COVID, pandemic management, pandemic surveillance. So what you're actually seeing is, and which is probably why I think the delays are ongoing with the second version of the bill being discussed and what's going to come out of it, is because the government is thinking, look, data gives us more pathways to design new policies, new frameworks, new infrastructures in a number of different areas, and we're going to stick to it. And I think so notions of privacy, notions of consent, the digital rights of users, I think have all been lost over the last year or so relative to what and how the government can operate as it collects more data.
Thank you. I mean, certainly, data protection laws and regulations need not, not be inconsistent for economic growth and innovation, as well as to protect individual rights. When we talk about data protection laws, it can do both, and that's sort of the approach that is being taken in Singapore as well. That you structure a law that provides for a good ecosystem, a good environment, and provides certainty for businesses, and they know when they can collect information, and it also provides data access and security. And now, on the other hand, of course, ensuring that there are minimum protections for individuals as well. Now, we go to Mulya, since you were the one who initially raised these issues in your last slide, right? So I'm sure you had more to say on these challenges.
Yeah, thanks, Warren. I mean, from the civil society side, there was great expectations that the draft PDP law would for sure be completed this year, maybe even at the beginning of this year. So, but that didn't happen. I mean, it's been since last year. It should have been last year. So they didn't complete. They didn't issue the law last year. So it's now this year. It's gone into the national legislative target to complete that law this year. But that's what we heard about last year as well, right? So now with the COVID-19 situation, it's just taken a bit of a backseat, and it's not, the different meetings that they're having at the House of Representatives, they're talking about other things, and they seem to think, okay, now this is not as urgent as it was. I mean, the COVID-19 and all its different impacts and different aftermaths of COVID-19 has taken a more prominent stage in political discussions. And so, but it is still going on. It's just not progressing as far and as quickly as it was hoped for. And part of it, the reason of it is because you had a second question, Warren, right, about the different needs of the populations, the different segments of population. How do they see this law or the urgency of this law? It's just not that high on citizens' agenda as well. Of course, we do have NGOs working on this, and they're for the right reasons. They're saying that this is an important regulation that we need to quickly complete, to quickly issue. But then, if you talk to the population, we did a survey or Kata data, the Ministry of ICT, sorry about that. Ministry of ICT did a survey last year about the digital literacy status of Indonesian citizens by province, and like 67% of the people of internet users that was surveyed, they admitted that they put personal information in their social media, so publicly. So 67% put their date of birth. 53.7% put their personal hand phone number. 29% puts their home address in their social media, and 22.5% lists their family names, their family members' names, and familial relationship, the relationship with those family. And so, I mean, people just don't don't see this as a very urgent need, perhaps because they think there's not that much there's not that much to lose if their personal data is leaked. I mean, Indonesia did experience that, several data breaches. You know, I mentioned that there was a data breach from the General Elections Commission, with 2.3 billion data being breached, and then there's a e-commerce site also experienced that in last year or the year before, and people said, you know, I'm still here, I'm still fine. So it's just it's very conceptual, and it's something that is not tangible for people. They want to be able to use the social media services that they have come to be that they have come to love, these different online tools, facilities, and if that means giving away some of their personal data, they seem to think that it's okay. So again, it relates back, a political process relates back to the demands of the society. If the society places this as at a higher level of priority, then of course the politicians will be discussing this more seriously.
Yeah, I mean, certainly it's a double-edged sword, right? Technology. On the one hand, of course, you have certain societies and cultures which did not traditionally, focus on privacy rights, for instance. So it's very hard to build up that capacity first, and that knowledge and the understanding of privacy rights and interests. And then the other issue is, of course, with people going online and social media, the sort of the expectations and the attitudes are formed by these big companies, and now they're used to sharing information rather than the other way around. And so it's very hard to put the genie back in the bottle. And so those are some of the challenges that we face. Let's go back to Natalie, because you've conducted all these studies on regionally. Is there anything that you can say about whether there's any impetus or lack thereof for there to be more harmonization when it comes to Asian jurisdictions, or when if we look at each other's laws a lot more? Because looking at some of these provisions, for example, the Indian bill, right? It's very much GDPR-like piece of legislation. So are we looking sort of too far away? Should there be more, talk amongst the Asian countries to try to ensure some form of consistency, at least in this region first, before we even, try to, go beyond that?
Yeah, thanks, Warren, for your question. Actually, before I answer that, I have a question for everyone.
Yes.
Right, about actually that discussion about digital literacy. I think when we talk about digital literacy in the data sense, it's more about, I think, literacy about whether or not people know what is being done with their data, right? And what data is collected, how they are used to, for instance, by tech platforms to give them personalized recommendations and all that. That's the kind of literacy we're talking about, right? And I keep going back to this question, and I've been thinking about this for some time, and I keep wondering also whether it's actually a question of literacy, or is it a question of trust, right? Do people not think about the privacy and the protection of their data because they don't know, or is it because they trust, right? These platforms or governments, agencies that's collecting their data and using their data. So it might be both, but I'm interested in hearing everyone's thoughts on this. And to your question about harmonizing, I've been actually trying to look for common themes, right? But I think that this idea of harmonizing our approach to like regulating data is something that's really challenging. I think on a high level, there is some recognition of, I really like, Karthik started off by talking about the different approaches to data regulations. There is a GDPR approach, which emphasizes the individual protection of privacy. There is like the light touch approach, right, that we see. But across the countries I've looked into, I think there is some high level recognition and consensus that data is something that needs to be protected, but there is also much value that, in terms of data being moved as well and shared. I think for very much a part of Asia, right, there is this recognition that the next, or rather the current wave of innovations, right, has to be data-driven, is actually data-driven. So, so there is actually, I think, some high-level consensus in terms of what is how we should try to ethically protect all this personal data while, protecting the individual privacy as well. And I think in some countries, right, where there have been very prolific and high-profile data breaches, we do have citizens that recognize the value of such protection. So they are very aware, like in Singapore, right? You talked about it. So, so yeah, we have citizens and because of the that mass level kind of citizen awareness, right? There is high level consensus that something needs to be done with data protection. But as to what it looks like, the infrastructural requirements, the policy requirements, I think there's the devil's in the details, right? There are actually many differences. And when we look at, I think, the implementations in each country, I think it's also very much informed by the kinds of socio-political context in each country, as well as some of the regimes that, and legacies, right, in the different societies. So harmonizing, right, at that level may not be so, I think, possible, but at a high level, I think there is some consensus.
Yes. Any comments from our other panelists? I mean, let's just take up your point on the trust issue, right? To me, for some countries, especially developing countries, it hasn't even reached that stage. Awareness is the first thing, and then the next thing is, do we even care? Because I know that there's some in society where, I'm just very happy that I even have access to social media. I don't have to pay for it. So, do they even look at personal data as an asset, as something important or not, right? Before you even talk about trust, because if it's not important at all, I know that people of a different generation, like my parents' generation or my grandparents, right? They share whatever information and they don't think there's any issues in regards to that as well. But let's go back to the other panelists and your comments on what's been said.
So I think on the question of trust, it's really interesting. I think what Warren said is absolutely true. I think discussions really haven't reached at that stage at a broad societal level where we can measure levels of digital trust and how and what kind of trust that citizens have as they engage digitally. But in my own sort of understanding and having spoken to a lot of people working on this issue in India, I think it's a lot of citizens engage very transactionally with their digital through various digital platforms. It's a very transactional relationship. So they get different goodies, they get different perks and benefits, and they often see their relationship with these platforms and services in that manner. They're not really thinking very deeply or clearly about trust, about consent, about how much data they are actually providing to these different services yet. But that's being done on behalf of them by various groups in civil society, by groups and organizations that are defending digital rights, that are taking on these big tech firms and other platforms and services, including some of those under the state, to just raise concerns relating to privacy and consent and trust. So I think it's still at a very transactional, instrumental level, and it needs to move further to one where the citizens collectively can begin to reflect and think about the implications of the kinds of data that they're providing as they interact, as they communicate online. And I'm kind of curious if that's the case in Indonesia as well.
Maybe I can just jump in. That's a really good point that is raised by Natalie, I think. Is it because of low literacy or is it because of high trust? For the case of Indonesia, I think it's not really a matter of trust. It's not that they trust these social media companies or they trust the government. I think it tends to be related to low literacy. Is okay. Good
We're
to be
back.
back. Yeah.
Okay.
So let me just continue from the point before. Is it because of low literacy or high trust? I think in the case of Indonesia, it's not so much of a high trust. I think it tends to lean more towards low digital literacy. But it's a good point that Karthik made, that people do make these transactions. And I think people, they might have low literacy, but I think they do take some kind of thought into what are the risks and rewards of me sharing this information. And for many people, they think that, you know, the risks are low. Of course, there's issues of data breach. The data breach has happened, and they've heard of, you know, bad stories of what happened when your data is breached. But they see that the likelihood of it happening to them is probably a bit low. So they manage these risks better. And so they keep using these services, and they keep sharing their data.
Thank you. Can you all hear me?
Yes, I can
Because
hear
just
you.
now there was a little bit of feedback. Yeah, I just want to maybe, let's talk about one more issue before we open up for Q&A in 5 to 10 minutes time, and which is to do with sort of data localization, the issue of data localization and also data sovereignty. What are the operational difficulties you envision in data sovereignty in developing countries after the law is passed? And anybody can start out first with the comments.
So maybe I'll start with that. I think the entire conversation around localization itself needs to be interrogated further. So what are the reasons for which countries want to localize data? Is it to, one, for law enforcement purposes, to have sufficient access to data when you want to undertake a criminal investigation or some sort of investigation related to a certain crime or any kind of public safety issue. So that's one. Second is foreign surveillance. They're worried about foreign surveillance efforts, and localizing data will help you sort of gain access and control the data. Give you a sense of that. The third is innovation, right? So there's the economic argument, right? We can have and create data processing centers at home, and which enables which creates a new economy around data mining, data analytics, and firms and companies that can engage in that service, right? So, but if you actually measure it on all these levels, localization really doesn't help. It doesn't really help you gain access to data for law enforcement purposes. It doesn't really help you when you want to. There's no evidence, sorry, that localization will help your economy or enhance innovation by creating data processing centers, or even the surveillance aspect, right? So if that's the case, then what's the point of having a law around which localization features at the center of the core? I think it's because especially in developing countries like India, maybe in Indonesia, that the government or the state feels like holding data, having access to data, enables them to undertake certain public policies, certain other kinds of responsibilities, which they would probably not be able to do without access to that data. Right? So it's a belief of some sort at the bureaucratic, at the institutional level, that having access and having sufficient and continued sustained access to data will help will help you actually achieve these different goals and priorities, right? So the reasoning for which localization is often advocated for is, has to be interrogated. Right? Now, having said that, I think one of the things in the report that we sort of talk at length about is the institutional apparatus or architecture that will eventually have to be created and managed to deal with issues under data localization. So in India, through the new law, there's a provision which calls for the creation of a data protection authority. So this DPA will be staffed by bureaucrats who will be tasked to ensuring that every organization, firm, community that collects citizen data in India is complying with a set of rules under which that they have to adhere to. Now, there's no way in which this DPA, even once it's created and once it's operational, will be able to do that at a country level. I mean, you're going to need more self-regulation, right, within organizations, by firms, by other communities. Instead of having one bureaucrat or regulator at the center who's managing this entire process of to ensure that all these different organizations are protecting data. So I think it's an impossible task to manage and regulate data at the country level. Right? And so any institution that does come up, whether it's a DPA or whatever kind of institution that the Indonesian government is thinking of, must be aware of this fact that we have to come up with new models of data governance. We have to think about managing data more at the community level. We have to think about having firms have internal rules that enable them to handle data and provide them to governments when required. So we're going to have to think more clearly about what are the different the governance structures that do exist, and not just at the national level, but at the community level, at the state level, or at different levels, and even at the firm level, to help them manage data. So localization, it's great to think about at the national level, but it's almost impossible to implement and enforce if we're going to get deeper into issues.
Yeah, I mean, certainly for countries like India and Indonesia, which is so big and there's so many provinces and towns as well to deal with. Mulya, any thoughts on this?
I agree with Karthik, and I think the point on data sovereignty or location of the data servers is more symbolic. It's more laden with nationalistic sentiments. Of course, the effectiveness of it is questionable, right? Even if you do have data servers in a particular country, like a global company has their data servers in Indonesia, and it's going to be encrypted. So Indonesians or whoever it is in Indonesia will not be able to crack it. And whatever data is they're going to be able to, they will have a mirror of it somewhere else. So it's in terms of effectiveness for data protection, it doesn't really matter, I guess, but it's more like symbolic. And when you talk about data sovereignty and location of it, it's more symbolic. So it's become a political issue. So yeah, that's what I think.
Yeah, just to add on, right? I agree with the observations that the debates about localization has, I think, been driven by actually more symbolic, motivations about sovereignty and drawing boundaries. But also, the concern about the surveillance, potential surveillance and security of about the data of private citizens, right? But I think, when it comes to actually looking at innovations, I also see, I guess this recognition and debates that, it's only when data actually moves, when data is linked with other data, when data is actually processed, that it gains value. So when it comes to, I think, the innovation motivator, right? I feel that that's debate about localization and whether or not to localize, right, then changes its trajectory a little bit, right? I see like instances where, like in South Korea, for instance, we have actually laws that allow for data to be pseudonymized, yeah, those actually data, right, once it's pseudonymized, then it can be used for projects and purposes, right, that's recognized as socially or publicly beneficial, right? Of course, there are debates and potential loopholes around what is actually defined as a public good, but that's actually one way to look at the way data can be processed, right, can be used for innovation.
Thank you to the panel. And now we come to the Q&A session. So now we'd like to ask the audience if they have any questions that may not have been covered during the panel discussion or during the presentations that you have for the panelists.
Hi, my name is John Lauder. I'm a research associate at ISAS. I'd like to thank all of the panelists for the very lucid explanation of data regulation. So my first question is for Karthik. I thought in your introduction, it was interesting that you said that for a lot of these countries, in terms of how they approach data regulation, they're also kind of sending different signals of their priorities to their external partners. And we see a deepening of strategic cooperation between the US and India, also with the EU. And many high-level summits are beginning to take place. So I'm wondering what types of priorities do you think that India is signaling to these countries? And do you think that because the EU and the US, because of cultural factors, approach data regulation in a different way, do you suspect that there could be any tensions, and what might those tensions be?
Take another question. Again, thank you for a very insightful discussion. I think you presented the complexities of what goes into creating a data protection act. Let me just kind of give a couple of comments before I have some questions. You've seen that in most countries, the law or legislation or regulation always lags behind technology. Technology is always one step ahead of the law. If it's in the case of e-commerce, we're still debating about the digital tax. Is it at the source or is it at the point of consumption? And data protection, right? You've seen the Cambridge Analytics fiasco, and after everything goes out, then we try to do something to fix the responsibility. So a couple of questions leading to that is, will legislation ever catch up with technology? Right? Are we at the mercy of these big tech companies that will always figure out a way to kind of stay ahead of the game? One scenario is like this. When we talk about data being a sovereign asset, what if I split the data, say I store the name of the person in India, I store the gender and age in Israel, I store the profession and education in the EU, and some of the data in the US. So who actually owns the data now, and what is sovereign about this? So you always will have a challenge saying, tech will stay a step ahead of the legislation. So the question then is, do we really want to protect the privacy of the data from a standpoint of harm or hurt to the individual if it happens? And if so, what are the guarantees? And will we ever converge to a standard where we all agree that the data of the individual at a private level is extremely important and confidential and important? Thank you.
Yeah, thank you. I also have a question about enforceability and how enforceable these regulations are. And given, as Karthik just said, that there are three elements: capital, state, and then the public, of course. And the public basically don't really care because they don't understand, including me, who I am supposed to be educated and should care about this argument. So, we have stated that should limit its own powers to protect their citizens. And a capital that in many cases is the one that actually fund the electoral campaign of those that rule the state, that have all the interest to have complete control of the data. And these two actors are those who should enforce or self-regulate. So what chances do we have that anything, I'm not saying something good, but anything at all will come out of the regulation except adding layer of bureaucratic procedures to very already bureaucratic policy environments.
I'm Namita, I'm a research analyst at ISAS. So my question is around, so you mentioned that data literacy is one of the major concerns. So there was this other talk that I attended a year ago where they said that direct data monetization could be a way to ensure that the general data literacy improves. So I'm curious to know if all three of you across your studies and the countries that you studied, is this a conversation that's happening, and do you see it as a feasible way where the individuals can get to decide who they are selling their data to and what that data is being used for, and they also get directly compensated for this? So is this something that the countries you study, is it something they're considering, or do they view it as something that can bring them at further loggerheads with the companies that they're already sort of, there's a competition for control over data?
Warren can't hear some of the questions, so I'm just going to start responding to some of them, and Mulya and Natalie will chip in. John, on the question on signaling, right? I think so the initial data protection bill in India was not great for the Indian economy. If you're looking at from a digital economy point of view, and you're hoping to generate more investment coming in, more tech firms to come in to help advance your innovation agendas, then the first bill was clearly not good, right? It called for localization. It was a very heavy statist approach at handling data going ahead. So it expected tech firms, it expected any kind of foreign entity that was operating in India to, first devise their own data processing centers and then hand over data whenever requested to by the state. The problem is that a lot of these big tech companies have their own data processing centers somewhere else, and they would prefer, largely for self-interest reasons. I mean, if you're Facebook, for example, data is crucial to your business model, right? So not only do you want exclusive access to that data, but you also want to have the right to process it wherever you want. I mean, if that's Iceland, then so be it, right? And so there was a lot of criticism from tech companies, especially American tech companies, after the initial bill. And that criticism then compelled the government to soften the localization stance. So any company, any foreign tech company now can transport personal data of Indian citizens abroad as long as they keep one copy of it in India. Right? So there have been changes that have been made since the original bill to the second one, largely because then capital, especially foreign capital and foreign tech companies, criticized the approach, and they said, look, if you want us to keep investing in India, if you want us to retain our interest in India's booming digital economy and work with Indian unicorns, help them scale up, help them become bigger, then you need to soften your stances on localization, which is what happened, right? And that too so what happened on the data side is similarly on the e-commerce side. On the e-commerce side, and again, the Indian government was was wielding a very heavy-handed approach in terms of organizing who operates within India's digital economy and what kind of rules they go by. But even those provisions were also softened. The same thing with the EU. So we have the EU-India summit, which is coming up in May. Data is a huge consideration and factor, and it'll be a big part of discussions there because given India's size, and given the amount of data that's generated in India, I think it's a lot of external actors, not just big tech firms in the US and EU, but all these other major countries would want to keep transacting with India on a digital level. And that will not happen unless India's rules and laws on the digital economy are interoperable with theirs. So there has to be a certain level of compatibility going forward. And I think even once this bill is passed, there are going to be issues around how data is collected and shared across borders. And my guess is that, and how the DPA, the eventual DPA, once it's operational, will work with the big tech companies that are based in the US and the EU. So there are going to be a lot of problems going forward on this front. So, but regulatory level, it's important that the Indian digital economy is not closed to foreign investment on this side, and that's only that's only possible if these rules are amenable. So clearly, so a lot of changes have been made there in response to capital. The question of legislation, I think whether legislation will ever catch up with technology. I think nowadays you have to ask what legislation and whose legislation, right? Are you talking about US law? US law governing a lot of these technologies, whether it's data, whether it's AI, whether it's cybersecurity, have tremendous power worldwide, right? And a lot of companies elsewhere are compelled to, because they don't want to lose access to the American market, are forced to comply with American laws, right? And the EU is the same way, right? If you want to process European data, then you need to comply with the GDPR and have a adequacy agreement for your country that fits GDPR requirements, right? So it's not just a question of whether your own legislations are up to technology, but also whether the other legislations that exist today are more important than your own. Because you don't, as a developing country, you don't really need to have legislations on these different issues, right? If you have firms that are operating globally, then as long as they comply with an American law or a European law, and if that fits their economic interest, then so be it, right? And which is part of the impetus of why countries like India and Indonesia are actually coming up with laws on AI and laws on data, on other aspects of technology, because they want to also compel and force other firms in other parts of the world to comply with their rules, to operate within their borders, right? So there are other questions around technology and how it's governed, which are also important relative to your own legislation. So that's, I don't know if there's any, so the question on, so Diego asked about enforceability, right? Will these data rules be enforceable once they are operational? Probably not for the first few years. I think it's going to take a long time to come up with an institutional structure that is able to manage the size of India's digital economy and the amounts of data that's generated internally by various actors, both public and private. And so there are going to be a lot of gaps. There are going to be a lot of loopholes. There's going to be a lot of regulatory, as I said, gaps, which have to be dealt with. So, which is why what firms do is going to be more important than the rules that the governments make up, because it's going to be easy to circumvent them or adhere to other kinds of laws in other jurisdictions, which are probably more robust than your own, right? And that's the same thing with India. So, a lot of the conversations that I've had with folks that are working on data issues in India, they don't expect the new law to be operational even 5 years once it's passed, right? So even once the DPA is operational 5 years, 7 years, it's going to take time to learn how to regulate data, what kind of rules to put in place to force these companies to provide different kinds of assessments of how they're doing, and then go from there. So which is why these foreign data regulations could be more important, right? The GDPR is more important. The American approach, whenever they come up with their own data framework, is going to be more important than what India or even Indonesia is doing now, right? So it's going to take a long time until it's enforceable. Actually, even the existing law in India, which is the IT Act, it is not enforced. There is no enforcement at all. So what a lot of companies are doing right now with respect to data, they're doing either because of foreign jurisdictions, or either they feel compelled to because their customers or their constituents want them to act. So it's self-regulation and actions that they're taking because of internal demands rather than what the government is expecting them to do. So that'll take some time. I don't know if there's any other, do you want to jump in on some of these?
Yeah, sure. Thanks, Karthik, for tackling most of the questions. I'll address, I guess, respond to some of the really great questions. So thank you, everyone. I think that question about whether or not legislation can catch up with tech is a really good question. And I agree with Karthik that, a lot of these tech companies, right, they are sort of governed and operating under US laws, right? So just to give an example, I'm currently in this, actually working on the issue of, this app tracking transparency framework by Apple currently, right? So as some of you would know, last June, Apple announced this framework, right? It took effect, I think, just a couple of days ago. Under this framework, right? Apple requires that all businesses, all apps, right, that actually collects user data for advertising purposes to kind of show a prompt, right? So this prompt will require users to agree whether or not they agree to be tracked, right? To actually clarify, this actually does not allow the apps to collect new information, but it is a notification. It is a notification for users to know that this particular app tracks your data, right? We have, I guess policies, right? That's actually coming from companies like Apple, and its rollout like that, globally, right? This is, of course, one of my concern always is how do users actually know how to respond to that? Do they even have a choice, right? In terms of saying, no, I don't want to be tracked, or if I agree, right? What are the avenues for me to actually learn about what data is being collected, what exactly is being tracked, and how are such data being used to actually personalize things for me? I think for me, it is that question of, I guess who's in the room, right, in terms of the conversation about how the tech platforms and how these policies are rolled out. And the question about data literacy and monetization, this is really an interesting one. For me, it's a question of how do we stuff the genie back in the bottle, right? Billions of users are so used to using free services in return for their data being used and being collected, tracked and used. How do we actually go back to a state where they can actually be compensated? And actually the other end of the stick is also how do we also allow for options, right, to come in for users that actually do not want their data to be collected and tracked. And maybe they are not interested in actually having their data monetized, right? How do we actually come up with a model where they can exercise that choice, or even whether or not that option exists for them is a question. I remember participating in a radio show locally, right, where I was asked the question when WhatsApp actually had their notification updates. In fact, that triggered many people to switch to Telegram and Signal. I remember being asked, right, what if we allow users that option of paying, right, so that they can stay on WhatsApp and still not have, their data being collected, right? And my question is actually, my response is whether or not there is a level of acceptance for users to even pay that, right? So to me, it's a question of what actually the individual user is actually agreeable or comfortable with accepting. So I do see actually discussions of this, actually, how do we come up with meaningful models, right? Sustainable models for data to be managed. Especially in the whole of last year, I was part of a coalition that organized a series of dialogues. It's called We the Citizen, right? Series of dialogues actually getting citizens from over 70 countries to talk about issues about the internet, right? And one of the themes that's being discussed is digital identity and their use of data. So from 70 countries, right, I think there's some support for that, but like I said, there's also this spectrum of citizens who actually do not want their data to be tracked. And how do we actually go back to a state where there's even like a sort of sustainable model for them to exercise that choice is a big question and big concern. I have no solution to that, but I think this requires a multi-stakeholder dialogue, right? The state, the capital, citizens, right? They have to be all in that room to participate in the dialogue. Yeah, I think Warren, you have some comments.
Yeah.
Mulya, any points to add first?
Yeah, sure.
Yeah.
This is a very interesting discussion that we have, and this is something that is very relevant. One of the audience asked about regulation, or not asked, but maybe commented, the second person, the regulation always lags behind technology, and that's very true. I mean, we live in a dynamic world where technologies change, and sometimes the regulation is still trying to catch up to regulate that technology. And before the regulation even manages to regulate that technology, the technology is already changing. So by the time you do get to issue a regulation, then it becomes obsolete. It becomes irrelevant anymore because the technology has changed. And now even the situation has changed with COVID-19 situation. People are rethinking their their relationship with data and how they perceive data. Maybe perhaps previously they were some were more keen on protecting data. Now with the situation with the COVID-19, maybe there's like more negotiations being done. Maybe I can give some of my personal data to help the greater good. But yeah, these are important questions. There's no, I don't have any answers, but I think we mentioned a little bit about the US and the fact that a lot of these big tech companies that are collecting data are based in the US. So people are looking at the US and US citizens, basically, right? What are they going to demand from their government to regulate these different social media companies, technology companies? I mean, we already see this. There's a dynamic relationship, right, between the users. The users, in some cases, a few cases, are also organizing themselves. For example, there's a union of YouTube creators. It's actually started in Germany, if I'm not mistaken, YouTubers Union. .org, and Germany has also adopted pretty tough laws against spreading hate on the internet. these can become, references, and it has become references, like the GDPR has become references for both India and Indonesia in developing their personal data protection laws. But again, of course, these are all very, very dynamic issues that we are trying to regulate here. And so the situations change, the technologies change, maybe our demands as citizens are also constantly changing as we look and reflect on what is relevant for us and to what exchange do we want to be regulated.
Yeah, thank you. I mean, certainly we talk about the US, there's vested interest in not having very strong data protection laws. Of course, some of the states have already produced, like California has their privacy laws and everything, but definitely it's not to the level of the GDPR, for example. And because all these tech companies are there, and the main asset is data and personal data, then of course there are other political and policy reasons at work behind as well. But I think I won't take a very negative view of things. I mean, certainly, even we talk about, and we bring it back to data again, right? And data protection laws, right? It's not really a matter of putting the genie back in the bottle. I mean, part of the genie can go back into the bottle. And this is the approach that has been taken in Singapore, right? Where you already have the use of personal data. So we have a law that just says, okay, now from this point forward, there are some of these requirements that you have to meet. And then we give organizations or data controllers 1.5 years to get prepared to meet these requirements. So in that way, yes, it's slow, but you can still use regulation to control what technology companies can do in relation to personal data. So and also, even in countries that do not yet have their own data protection laws, if you're talking about organizations or data controllers that function across jurisdictions, and a lot of these organizations do, they have a presence in a lot of different countries, then it behoves them to really comply with more matured laws in other countries, not just because to instill trust, but also because legally they are required to do so already. So it may be operationally, it may make more sense for them to have a consistent approach, and to have a consistent approach, they should comply with the most stringent requirements. And so, and also a lot of these laws have extraterritorial effects and scope as well. Right? The GDPR itself has extraterritorial scope and effect, and the Singapore PDP as well. And I'm sure the Indonesian and the Indian laws also have some effects as well. And so you still have to comply with them at the end of the day. So there is a sort of an interest, there is an impetus for self-regulation, both to create trust in the user, as what we've seen with the WhatsApp situation, where if you don't have the trust, if you lose the trust, you lose the customers. And then also the regulators can step in at a certain point to rein in some of the usage of personal data. And we are at 4:50. Thank you all for your questions, and also thank you the panelists for your responses. And I will hand things back over to the organizers on this. If there are any further questions, I'm sure we can address them, in future meetings as well. So I'll pass things over to Dr. Ronojoy Sen, who will be giving the closing remarks.
So Dr. Ronojoy Sen will now present the closing remarks for the conference. Dr. Sen, please.
Thanks, Rajiv. It is my duty to bring the discussion to an end, and I won't take up any more of your time. But I'd like to just once again reiterate the importance of the contents of the report that was just released. In fact, it is not very often that comparative studies of India and Indonesia, the two most populous democracies in Asia, are conducted. And these two countries, of course, have much in common, but also significant differences. This report on regulating data in India and Indonesia is a welcome exception to this trend, and hopefully a precursor to more such research. I would like to thank everybody who made this report and this event possible. First, on behalf of ISAS, our heartfelt thanks to KAS for funding and making the project possible. Aishwarya and Gisela, both of whom are not physically present, were responsible for incubating the project and carrying it through. Thanks to Stefan who took over from Gisela, and Carol for handling the accounts. Christian, as always, has been a very good partner, and he gave his blessings to the project. Thanks to CfDS and Dia, Janitra, Mulya, Anisa and Raka in particular for being such excellent partners and research collaborators. At ISAS, the report would not have been possible without Karthik's untiring efforts and Prof. Rajamohan's enthusiasm, as well as Shalini's accounting skills. Today's event was made possible due to Harnek, Jordan, Yusuf, Rajiv, and Sheila. And last, but definitely not the least, our gratitude to Warren and Natalie for kindly agreeing to take part in today's event, and to you, the audience, who were physically present, as well as those who were online, for taking part at a time which is extremely stressful for many of us, and for posing very challenging and lively questions. If I have inadvertently left anyone out, my sincere apologies. Thank you, and have a very good evening.
Thank you, Dr. Sen. We have now come to the end of the panel discussion. On behalf of KAS, ISAS, and CfDS, I would like to thank you for your participation. Please kindly exit the ballroom, as no intermingling will be allowed due to COVID restrictions. We look forward to seeing you again. Have a good evening.